Folks, hello. Welcome. I'm here with Marion Sandilands, who's a constitutional lawyer with Conway Litigation, and we're talking about the Alberta Sovereignty Act. So, after months of speculation over what would be in it, we finally have a draft of the Sovereignty Act, or as it's now called, the Alberta Sovereignty Within a United Canada Act. And it's an interesting bill, right? Because it's obviously about enabling the province of Alberta to challenge perceived federal overreach. But the types of challenge that it envisions are a departure, I think, from the constitutional norm in Canada. So to begin, Marion, maybe you could walk us through the way that you'd normally expect a province to challenge the federal government when it thinks that the feds have done something potentially unconstitutional.
Sure, happy to be here. So normally when a province sees a federal law that they think trenches on their jurisdiction, what they would normally do is send a reference to their Court of Appeal. And they would ask the Court of Appeal to rule on whether the federal law trenches on their jurisdiction, or whether it applies, or whether it conflicts, etc. And that's really how the federalism system works. So we have two levels of government. We have the federal level and the provincial level, and the courts serve as the arbiter between the two whenever there's a conflict about jurisdiction.
So that's the norm, right? But the proposed Sovereignty Act envisions a very different mechanism for launching an effective challenge against perceived federal overreach. So what is this quite different type of challenge that the bill describes?
So this is quite different, and it's quite unique to this new law. So what the Sovereignty Act purports to do is when the provincial legislature deems that a federal law is either unconstitutional or potentially harmful to Albertans, the provincial legislature can pass a resolution to that effect and saying, this law is unconstitutional or harmful to Albertans. And this then gives Cabinet the power to do a variety of things, including, from my understanding, a Cabinet can order a provincial body to not follow the federal law. And provincial Cabinet can also do things like rewrite, I think, the legislation. It talks about substituting or putting in its own provisions in place of the federal law. So these kinds of powers, I've never seen anything like this before in Canadian law.
So it's novel, but the question on everybody's minds obviously is it constitutional? I mean, it's certainly a departure from what we'd normally expect provinces to do, but is it also a departure from or a violation of constitutional laws or principles?
So it seems to fly in the face of a very basic principle of how federalism works in Canada, which is that we have two orders of government, provincial and federal. And when there are disputes about which level of government has jurisdiction or whether one level is trenching on the other jurisdiction, those are worked out through the courts. They're not worked out by one legislature or the other. So that's the basic way that the federal system works in Canada. This act tries to remake that by saying that the provincial legislature can, on its own accord, basically decide, instead of a court, that a federal law is trenching on provincial jurisdiction, and then take immediate action in response to that. So that's the basic logic of the Constitution being kind of rewritten here.
So there are a number of potential constitutional defects, right? But what's the remedy for that? But by which I mean, at this point, which constitutional actors are actually capable of hitting the emergency brake, let's call it?
So this is the crystal ball question, I guess. There are few possible ways that this act could run into a challenge. The lieutenant governor a few months back floated the idea of refusing, withholding royal assent to the act. So that's possible, although I think quite unlikely. The federal government could use its power of disallowance to disallow this act, although that power hasn't been used for several decades. And in 1998, the Supreme Court of Canada intimated that that power had fallen into disuse. The federal government could send a reference directly to the Supreme Court about this provincial law. It has the power to do that. Another province could also potentially send a reference to its own Court of Appeal on this legislation or something like it to get a ruling from its own Court of Appeal on that, which would probably go up to the Supreme Court. And then another possibility is that an individual or an organization could challenge the act, particularly if it's actually used for something, then whoever it's being used on could potentially challenge it, and that would trigger a challenge to the act, which would probably make its way through the courts.
So I want to open this up a little bit and put it in context, because interestingly, this isn't the first time in recent years that a province has done something unconventional that challenges the constitutional status quo, because we've also seen, for example, an uptick in provincial recourse to the notwithstanding clause recently. That's unconventional. And we've seen two provinces, Quebec and Saskatchewan, attempt to unilaterally amend laws that are part of the Constitution of Canada. So my question is, do you view the Sovereignty Act as part of a larger shift, maybe, of which these other instances are part as well, in a shift in the sort of balance of power in Canada? And if you do, where does this shift potentially lead?
Right. So I think there's a lot going on right now in the Constitution of Canada, like a lot. And I think there's two key features that I've noticed. First of all is the radicalness of the types of things we're seeing. And second is the speed at which we're seeing them coming and the acceleration of that. So we've had uses of the notwithstanding clause. We've had two attempts to amend the Constitution of Canada. We've now got an attempt to bypass the Constitution from various provinces. We've had several developments since about 2018, 2019. Most of these things have happened in 2022. And by my accounts, three key things have happened just in the month of November 2022. So I'm going to try to review them as quickly as possible. So I think I'll go by province. So we've got in Quebec, we have Bill 21, which was in 2019, which preemptively and totally used the notwithstanding clause in a way never done before in Quebec or anywhere. And then in 2021, we got Bill 96, which does many remarkable things, but the two I will mention are, again, first, it uses the notwithstanding clause the same way again, on a much bigger scale because of the scale of the legislation. And secondly, it purports to amend the Constitution Act 1867 to add two new clauses, 90Q1 and 90Q2. This had never been attempted before by any province. I'll just leave it at that. That was an unprecedented move in 2021 and 2022. In Ontario, what have we been seeing? We've been seeing up until 2017, Ontario had never used the notwithstanding clause ever. And since 2017, we've seen it used, by my count, 3 times. I would call it a dramatic uptick. Most recently in November with a labor bill. Now that was actually repealed because of public outcry, but the reflex to use this has gone from being taboo to being, I would say, almost routine or seen as a tool that is routinely available. In Saskatchewan, we saw November 1st, 2022, the Saskatchewan First Act, which seeks to assert Saskatchewan's jurisdiction in Canada. And interestingly, attempts to amend the Constitution Act 1867 by adding what? 90S1. So first of all, there's a clear link there between Bill 96 and the Saskatchewan First Act. There's a sequence in time. And again, an unprecedented attempt by a province to amend the Constitution Act 1867. Well, the precedent being Bill 96. So now we're looking at potentially a fragmentation of the Constitution Act 1867 when each province tries to amend it. So all of these actions together, obviously they come from different roots, different sets of frustrations, different grievances, different political contexts. But the common thread that I see in them is this trivializing, in my view, trivializing of the Constitution and of the role of the courts, and using rhetoric with to undermine the integrity of the Constitution. And I think that's a matter of great concern, especially when we think about what's going on in the world generally and what's going on with constitutional democracies generally. I think when you look at all this together, we see a phenomenon that's manifesting, that's been accelerating. I don't know where it's going, but I think it's a matter of great concern.
So the question that I'd like to end with is, well, this moment where you see different provinces in Canada sort of pushing at the limits of what the Constitution permits, I think is an opportunity for us to reflect on what a Constitution is, on what it's for, on what it does for us as Canadians. Constitutions have different dimensions. They're legal texts, but they're also fonts of public morality. They foster accountability practices, etc. So maybe you could end by reflecting on what you think a constitution's for and what you think it gives all of us.
I absolutely agree. The Constitution should not just be some document that sits on a desk somewhere. It really it should be an expression of who we are. And I think perhaps there are two levels at which it should be understood. First of all, symbolic, like you say, an expression of who is Canada as a nation. And secondly, legally, what does it do? It sets out what the state can do, but also the limits on the state's power. And those two features are really important. And as we see the integrity of the Constitution being whittled away here with these kind of moves by these various political actors, I think it undermines the ability of the Constitution to do its job, and particularly that second part about limiting the power of the state and preventing abuses of power. So that's something I'm very concerned about as we go forward and we see more and more of these moves to undermine the integrity of the Constitution.
Marion, thanks so much for that, and thanks so much for joining us today.
Thanks so much, Richard. My pleasure.